I apologize for evidently being late. The schedule that we had initially thought was that I had been told that we would be lunching from 12:30 to 1 and then talking at 1. But evidently there were more people than there was lunch, so lunch ended more quickly than expected. So here we are. So this is good because we have some time. I was actually just talking about affirmative action in my constitutional law class today, which was why I'm a little bit later than I would have expected, because it was a lot to talk about. But now we're on to a totally different topic. Okay, so maybe I'll just talk for a little while about a couple of things, and then we'll see what questions you have and what you most want to talk about. In terms of updating all of you about what has been happening in connection with civil liberties, the war on terrorism, etc., I was noticing that one of the titles that was given to this session was about the rights of enemy combatants. So certainly that's one thing that I think we want to talk about, since that's the title, the whole question about people being detained. I thought another topic that people might also be interested in are some of the things about surveillance. And we can talk a little bit, too, about some of the litigation that has been going on. There's begun to be some litigation on some of these topics, which I thought you might like to know about. So is that about what you're interested in, the detentions and the surveillance? Okay, then let me start with the detentions, because I think there's a lot of actually misinformation about this, and there's certainly a lot of lack of information. After September 11th, as of about November of 2001, the Department of Justice was scrupulously announcing how many people it had detained in connection with their investigations about what had happened on September 11th. And in November of 2001, they released their last number, which was 1,186, or maybe 1,187, was somewhere around there, because they were trying to show everybody how much they were accomplishing and how many people they had actually detained and how well they were doing. After that, they decided to stop announcing the numbers. And part of the reason for that was that they became concerned about the fact that people wanted to know, well, who are these people? On what basis are they being detained? And so out of all these, have you found any terrorists yet? And they decided to take a different approach, and instead of constantly announcing who they were detaining, they decided not to mention at all what was going on and to just kind of keep that close to their vest. Well, since this is an event partially sponsored by the ACLU, I don't have to be totally neutral. I can tell you about some of the things the ACLU has done with respect to this. And one of the first things that the ACLU did was to file an action under the Freedom of Information Act in the District of Columbia, asking for information about those 1,186 or more people, who they were, on what bases they were being detained, where they were being detained, whether they were actually seeing lawyers, just what was happening. The reason that the lawsuit had to be filed is that the Department of Justice declined to provide that information under the Freedom of Information Act. And you may be aware of the fact that Attorney General Ashcroft and President Bush have taken a much more restrictive view of what information they want to divulge under the Freedom of Information Act than had previously been the case. And Attorney General Ashcroft has instructed all agencies to fight the production of information anytime they have a plausible argument against providing information. So, with that predicate, the ACLU and other groups ended up in court. The judge in that case in the District of Columbia, Gladys Kessler, listened to the government's arguments about why they didn't want to have to tell how many people they were locking up or who they were. One of the chief arguments that the government made as to why they didn't want to talk about who they were detaining was that they were interested in preserving the privacy of the people who were being detained. They thought it might be embarrassing. So, there was that argument. The other argument was that the more that the enemy knows about who we're locking up and what our investigative patterns are, the more it could be helpful to them, and that therefore we don't want that information to get out. Well, Gladys Kessler listened to all these arguments, and she was not convinced, and she did order the government to divulge a fair amount of information about what they were doing, who they were locking up, and on what bases. And because this ended up not happening until, I think it was August, that she actually issued this order. At that point, she was also wanting them to declare how many people were still detained, as opposed to the people who had initially been picked up. There is a very interesting document that is probably still on the ACLU website. If you click on this case, it's called Center for National Security Studies versus Ashcroft, I believe, the title of it. There's a document that you can see, an interim document that the government provided as part of what Judge Kessler had ordered them to do, which is a whole list of all the detainees, and everything on these multiple pages is blacked out. It's black ink line after black ink line, and you can't read anything. And it's very interesting. So Judge Kessler's order is actually now pending appeal in the D.C. Circuit. They've been sitting on this one for a long time and haven't decided what we, the public, are entitled to know about who it is that's detained. So here's what we sort of know informally. We don't really know how many people the government has detained because they're refusing to tell us. We know that there have been quite a number of people who were detained initially who were not citizens. A lot of people were picked up on suspicion of immigration violations. What's been happening in terms of detentions has been falling particularly hard on the immigrant population. So a whole lot of people were locked up. The Department of Justice had claimed initially authority to detain non-citizens for as long as they wanted. The USA Patriot Act, which you've heard something about, actually gave the Attorney General the authority to detain non-citizens for any reason at all, just he's suspicious, with nothing in particular, for 7 days, but that's it. So how can they hold people for longer than 7 days? Well, they're holding people, for one thing, or have held people, who they suspected of immigration violations. Anybody who's overstayed a visa, anybody who did something that was considered fraudulent on their forms for application for a visa, anything like that. So some number, a fair number of the people who were detained were people who were suspected of immigration violations. Of those people, they were subject to deportation, which is why they could be held, because they didn't have a right to be in the country in the first place. What the FBI had decided, however, was that before deporting anybody, they were going to try to figure out whether or not that person knew anything about terrorism. So it was only a kind of a reverse presumption of guilt, because they would just hold on to people and detain them and not even deport them until they figured out that they actually wanted to clear the person. Now with 1,000 people, that's a lot of people hours to spend. So a lot of these people weren't cleared. So many of the people who were being held were just being held because they were deportable. They had violated some immigration law by overstaying their visa or whatever. And the FBI had not yet gotten around to examining their case to figure out whether or not they in fact had anything to do with anybody in Al-Qaeda or anyplace else. Well, the people who are detained on immigration violations and who are subject to deportation don't have a right to counsel, in the sense that if they can't afford a lawyer or can't find a lawyer, no counsel is assigned to represent them. They're allowed to have lawyers if they can find lawyers. So what would happen is a lot of these people were being detained in jails and prisons all over the country. And if they found their way to a lawyer, the lawyer could represent them. And what happened at that point was one of several things. If the lawyer who was representing them filed a habeas corpus petition or asked for some review of why is this person being detained, the FBI would put that person to the front of the list, they would do their security clearance and deport them. So they would just get them out of the country. So the way a lot of these people got out of detention was they were deported, and there was that. The second thing that happened was that the people who had lawyers, if the lawyers would file a writ of habeas corpus saying, how come you're holding this person in preventive detention for a long period of time? You haven't charged them with any crime. You're not actually deporting them. What are you doing? The Department of Justice would say, oh, you're having a problem with that? All right, we'll charge them with the crime. So people were then charged with criminal immigration violations, and then that gave the government a predicate to hold them because they had overstayed their visas and a number of immigration violations that could be prosecuted as crimes. So it was actually, I talked to a lot of lawyers around the country who had a lot of problems with how to handle this, because if you squeaked on behalf of your client, sometimes you could just get your client deported, which was what was going to happen anyway, so why not accelerate that? But sometimes there ended up being these additional criminal charges about immigration violations. Okay, in addition to all the people who were being held because of possible immigration violations, the non-citizens, there were also something like a dozen people who were being held as material witnesses. The idea there was that they were people who the government thought might know something that they could tell to a grand jury, something about terrorism or Al-Qaeda or September 11th or something, and used the material witness statute, which is in Title 18 of the United States Code, which provides that if you're having a trial and you believe that you're not going to be able to get somebody to show up who you'd like to subpoena as a witness, you can lock them up pending the trial so that they can give evidence. Well, if you think about the difference between there's a trial going on, you have somebody who's a material witness, and you just want to hold on to them and lock them up pending the trial to make sure that they don't run off, that's a lot different from some of these people have now been detained for many months on the theory that maybe they'll be brought before a grand jury one day. So that's a very expansive theory. This theory was challenged under the material witness statute. People who are being held as material witnesses do have a right to counsel. So lawyers were assigned to represent, I'll tell you about two people. There's a Mr. Awadallah, who ended up before Judge Shira Shinlin, and Jose Padilla, who you've heard of in other contexts, the so-called dirty bomber. Both of those people were being held as material witnesses, and they both challenged the constitutionality of having this statute applied to them very expansively to cover the grand jury witnesses as well as anybody else. And there were two different rulings in the Southern District. Judge Shira Shinlin ruled that, in fact, it was an unconstitutional application of the material witness statute in the Awadallah case. Judge McKasey, on the other hand, ended up with an opposite ruling in Padilla's case and ruled that it was a constitutional usage of the material witness statute. However, as I'll talk about in a couple of minutes, the government went on to other theories as to why they're holding Jose Padilla. So what is now pending appeal to the Second Circuit is Judge Shinlin's decision in United States versus Awadallah, whether or not it is permissible to use the material witness statute to hold on to people indefinitely who we think know something about terrorism. That's about the story of what we know about why different people were detained in this country, other than Jose Padilla and Hamdi, who I'll get to in a minute. Out of all those people who were detained after September 11th in connection with terrorism investigations, how many have been convicted of any sort of crime related to terrorism? Zero. Nobody. And part of what's going on here is that the government is not anxious to bring criminal charges in most of these cases. Again, originally, at the point where Zacarias Moussaoui was being prosecuted, the government's approach was evidently that they wanted to show some activity and they wanted to show prosecutions. But what they're doing now instead is more the approach that they're taking with Hamdi and Padilla, of avoiding criminal prosecution and instead just taking other measures. Well, one interesting thing in terms of the government's response, what's happened on the prosecution front, is the General Accounting Office issued a report a couple of weeks ago that I thought was very interesting. It got a little bit of press, that was analyzing the reports that they've been getting back from the Department of Justice, which asked all the U.S. attorneys to report on how many terrorism cases they had been working on and prosecuting. It's, how are you doing? What's happening here? Well, I was just actually hearing from James Comey, who's the United States Attorney in the Southern District, and he said he saw this report. He was pretty amazed because he reported that he had 7 cases that he considered related to terrorism somehow. And then he said he looked at the reports from the District of Virginia, which said they had 200. Okay, and New Jersey said they had 62. And he's thinking, how is this happening? Well, the GAO said it isn't. They said they're exaggerating. Every case of immigration fraud they're counting as a terrorism case, even if there's really no connection with, proved with terrorism, on the theory that maybe people who are being fraudulent about their visa applications or violating immigration laws are also terrorists. So you hear prosecutors talk, and that's where they're starting. They want to screen everybody who's committing immigration violations to see if they know anything about terrorism. And as you know, this is a policy that has been particularly affecting Muslim and Arab men. Another interesting story that I actually just read a few days ago was from the Philadelphia Inquirer, which broke down the 62 terrorism prosecutions in New Jersey. And according to the Philadelphia Inquirer story, 60 of those 62 terrorism prosecutions classified by the federal prosecutor in New Jersey were of Middle Eastern students who had hired an imposter to take their English proficiency tests. 60 of the 62. Okay, again, any connection with terrorism, the government says, well, that's the kind of case we're looking at because we want to see if. We were very suspicious and one of these students was a Saudi and he knew how to fly a plane. Okay, so we were looking into it. Okay, that's the investigations, but in terms of the prosecutions, zero. 0 people have been convicted for anything having to do with September 11th. Okay, final category of detainees, category of 2, Yasser Hamdi and Jose Padilla. I'll start with Yasser Hamdi because in some sense he's the less hard case for the government. Hamdi, as you probably know, was captured in an active combat zone in Afghanistan, and he was brought to Guantanamo Bay with the other people who had been captured in Afghanistan. At some point, somebody realized that Hamdi was in fact an American citizen. He'd been born in Baton Rouge, Louisiana, and then his family moved to, I believe it was Saudi Arabia or wherever they moved, someplace out of the country. But he was still an American citizen because under our immigration laws, if you're born in the United States, you're a citizen, period. Doesn't matter if you stay here more than 3 minutes or not, you're an American citizen. So the government became concerned about leaving him in Guantanamo, where, as you probably know, the government has been arguing that the detainees in Guantanamo have no rights at all, not even really the rights of prisoners of war, because they're, quote, unlawful combatants. Now, I don't know a lot about international law, but under the rules of war, here's my understanding, mostly from my colleague Nathaniel Berman, about what the rules of war are all about, this whole idea of lawful and unlawful combatants. The rules of war are mostly to prevent soldiers from being prosecuted after the war. And soldiers can't be prosecuted for murder. So if you are somebody who is following the leadership of your country, and you have to join the army, and you have to serve in the armed forces, and you go over, say, to Iraq, and you kill somebody, what the rules of war say is Iraq should not prosecute you if they catch you for murder, because it's not murder. You have a license to kill, in a way, because you're a combatant. You're a lawful combatant. Your government told you to go to war and kill somebody. You shouldn't be prosecuted for a crime. The Geneva Convention is sort of a political method of trying to make sure that our people won't be prosecuted for crimes by promising that if Iraqis come over here and kill people, if it's a war and they're soldiers, then they can't be prosecuted for a crime either. Now, the distinction that the Geneva Convention draws between lawful and unlawful combatants is sort of the difference between our idea of soldiers. They talk a lot about emblems and insignia and uniforms. If you're in uniform, you're wearing your official country's uniform, and you go off with your officially issued bayonet and you go to war, you're a lawful combatant and you're not supposed to be subject to prosecution in whatever country captures you. Unlawful combatants, on the other hand, are people who are not wearing insignias and emblems. Classic example of unlawful combatants are spies and saboteurs. And there was a case in the 1940s, the Quirin case that a lot of people have talked about, that involved 8 Nazi saboteurs who came to this country by submarine and then were supposed to commit acts of sabotage. Okay, according to the Supreme Court, they were unlawful combatants, and therefore they actually ended up being charged with crimes, all sorts of crimes of violations of the rules of war, because they were unlawful combatants. They were tried by a military tribunal. Side story, one of the reasons apparently why they were tried by a military tribunal was that the way the FBI caught the Nazi saboteurs was that one of them turned them in. One of the saboteurs came to federal authorities and said, "We've just landed in this country, me and my friends, and we're about to do these things I thought you'd like to know." And the FBI waits a few days, and all of a sudden they announce that they've found these guys and have arrested them. And what some historians say is the reason that the authorities were so interested in having a military tribunal was they didn't really want it to come out that they had been a little slow on the uptake here, that the evidence had been handed to them. And so they were looking for the military tribunal because they wanted to do this in a little bit more secrecy. Okay, so that's the story about lawful and unlawful combatants. Well, when Mr. Hamdi was moved from Guantanamo Bay to the naval brig where he is now living in Norfolk, Virginia, what the government said was, this is not about military tribunals or not military tribunals. He hasn't been to a military tribunal, and evidently nobody's intending to send him to a military tribunal. What he is he's locked up. How long is he locked up for? For the duration of the war. What the Bush administration argues is we're at war. Under war, we have the right to detain enemy troops so that they can't rejoin the enemy, and we get to detain them until the end of the war. That's why we're detaining Hamdi. He's an enemy combatant. Okay, he's an unlawful enemy combatant, and therefore if we wanted to, we could prosecute him for a crime. And the other theory the Bush administration has is that because he's an unlawful combatant, he can be subject to detention, just at the say-so of the president. Hamdi's designation as an enemy combatant was made by the president personally, which I think is a good thing. It's really kind of accepting political accountability for making that decision. But it was based on a hearsay affidavit. And the affidavit, which I have not seen, I've just read things about it, apparently says things like, well, an informant told us this and we're not 100% sure it's reliable, but. And it's reason to really, if you looked at this in a criminal case, you would say nonsense. Couldn't possibly be a reason to lock people up. The affidavit says Hamdi was caught in an active combat zone in Afghanistan. He had a gun, and he had gone over to work with Al-Qaeda. Okay, on the basis of that, what was in the affidavit, the Bush administration designated him to be an enemy combatant and claimed the right to hold on to him. Well, at that point, Mr. Hamdi ends up, through his father, filing a writ of habeas corpus. I shouldn't say Mr. Hamdi because he probably doesn't even know about this to this day. Hamdi's father, on Hamdi's behalf, files a writ of habeas corpus. And you all know enough about habeas corpus probably to know that that's how you challenge detention. Anybody who's detained for any reason can bring a petition of habeas corpus for a writ of habeas corpus into federal court, and then the federal court examines whether or not the detention is lawful. Under the Constitution, Article 1, Section 9 has what's called a suspension clause, which says the writ of habeas corpus shall not be suspended except in cases of rebellion or invasion where the public safety so requires. Okay, being that that's in Article 1, it looks like probably it's Congress that would have to decide to suspend the writ of habeas corpus. And even if we're at war, we certainly haven't been invaded, and this isn't a rebellion. That provision applied, according to President Lincoln, during the Civil War, which was a rebellion, but it doesn't apply now. So initially, the Bush administration had been taking the position that the enemy combatants were not entitled to bring a writ of habeas corpus to challenge their detention because they're enemy combatants, and if they had been detained in Afghanistan, they wouldn't have been able to do this. Their position has evolved on that, however, and they're now actually allowing that it's permissible to challenge your detention by habeas corpus. However, next problem, I don't remember whether it was in Hamdi's or Padilla's case, but in one of those cases, when a habeas corpus petition was filed to review the constitutionality of the detention of one or the other, the government actually argued that it was improper because it hadn't been signed by, Hamdi or Padilla. How is that? The basic argument that the government made in Hamdi is not only does the government have the right to detain Mr. Hamdi, he is entitled to a writ of habeas corpus examination, because there it is, we can't suspend that. A federal court, while the courts are still sitting in this country, does have authority to look at the designation to see whether or not he's been properly kept. However, when the Fourth Circuit in the Hamdi case looked at the president's designation, the important question that they had to decide, of course, is what standard of review are they going to use to decide whether or not there's sufficient evidence here. Well, not surprisingly, the Fourth Circuit decided on an extremely deferential standard of review. The district court had ordered the government to come up with more information. Well, who's this informant, and how did he know, and what was Hamdi doing with the gun in an active zone of combat? How do we know he wasn't just a bystander? How do we know it was the Northern Alliance that actually captured him? How do we know they got it right? How do we know he's really an enemy combatant at all? Okay, what the Fourth Circuit said was, well, we know because the president said so. Okay, we have to be deferential. There's some evidence here, and the fact that he was caught in an active zone of combat, that's enough. The Fourth Circuit says the courts cannot be more demanding than that, because we're at war. How do we know we're at war? The president says so, and Congress has in fact authorized a use of force, and that's tantamount to war. While we're at war, the president is the commander-in-chief. Under separation of powers theory, therefore, the president has to be able to do anything he needs to do, anything he thinks is advisable to keep the country safe. If you have somebody on the battlefield in Afghanistan, you can just hold on to them for the duration of the war. For that matter, if we're at war, you can shoot them. And therefore, if all the president wants to do is to detain somebody in this country because he thinks it's necessary, we have to defer to that. Fourth Circuit also says if we don't defer to that, if the district court is right, that we have to start testing this affidavit to try to figure out what Mr. Hamdi actually was doing in Afghanistan and whether he really is an enemy combatant according to judicial review, then what we'd have to be doing is subpoenaing evidence from off there in the battlefield. And how can the government do that? How can they fight a war if their object is not only we want to win the war, but we also have to document who has a gun and who's shooting at us, and we have to write it all down so that we'll be able to answer to a court. So the Fourth Circuit says inappropriate, can't happen. Has anybody asked Mr. Hamdi what he was doing there? No. Mr. Hamdi has not been permitted to see a lawyer, period. Why not? Government has two theories for why Hamdi, well, actually three, why Hamdi doesn't get to see a lawyer. Theory number one, does he have a constitutional right to counsel under the Sixth Amendment? No. Sixth Amendment says you have a right to counsel in all criminal prosecutions. Is anyone criminally prosecuting Hamdi? No. Okay? Sixth Amendment done. Can Hamdi claim that he should have a lawyer with respect to his habeas corpus petition? Just help him out to file that if that's what he cares to do. Nobody's been able to ask him, but his father has permission as his, quote, next friend to be able to file the writ on his behalf. Well, the government has two problems with the right to counsel argument. Argument number one, what if the counsel was a conduit? Lawyers deliver messages to people on the outside. Maybe the lawyer would do it on purpose. Maybe the lawyer would be involved. Or maybe the lawyer would be a dupe. Maybe Mr. Hamdi has very clever instructions that if he's arrested, he can deliver a message to the other terrorists. And what if his lawyer doesn't know that something that Hamdi is saying that the lawyer later tells somebody is a message? Big problem, could be a security risk. Better not let him see a lawyer. That's argument number one. Argument number two, we don't want him to see a lawyer because we're interrogating him. We're trying to break him down. It's like this guy who's just been a Khalid who's just been arrested in Afghanistan. We want him to provide information. If we let him see a lawyer, that's going to interfere with our program of trying to break him down so he'll provide information. Okay? What about the Fifth Amendment privilege against self-incrimination? If Hamdi is in fact a citizen, doesn't he have a right to remain silent? Well, for those of you who are familiar with Miranda, Yes, there is a right to remain silent, and you have a right to counsel if you're being subjected to custodial interrogation. Is that Hamdi? Sure. However, what the government argues, and this is a question the Supreme Court is considering this very term, is that there is no violation of the Fifth Amendment privilege against self-incrimination unless evidence that was obtained as a result of the custodial interrogation without counsel is used in court. That the privilege against self-incrimination is about testimony, and you don't have just a right not to be interrogated in the absence of counsel. The case, for your information, that the Supreme Court is considering this in is called Chavez versus Martinez. Some of you have heard about it. It's a case where a guy who was involved in a scuffle with the police ended up in the emergency room, and one of the local police authorities came in to question him, despite the fact that he was in intensive care and in terrible shape, interrogated him without giving him Miranda warnings. He kept saying, "I don't want to talk to you." They kept interrogating him anyway. He ended up being so upset he was never prosecuted for anything, but he's in terrible physical shape. He brought a 1983 action challenging the constitutionality of the action of interrogating him despite what should have been his rights under Miranda. And the question the Supreme Court is considering is whether or not he actually had rights at that time, or whether his only right is to not have any evidence used against him in a criminal proceeding. Okay, so how is the Supreme Court going to answer that question when they know about Mr. Hamdi? They know what the issue is. Okay, the second case, Jose Padilla, also an American citizen. He prefers actually to be known by the name of al-Muhajir, but nobody calls him that, perhaps because he didn't get to write the court papers himself. So the court papers all call him Jose Padilla. He was originally held as a material witness and therefore had counsel assigned. Donna Newman, who you may have heard of, she's talking a lot on NPR and so forth. So she's assigned to represent Mr. Padilla, and she challenges the material witness warrant, etc. At some point, the government decides that despite the fact that Judge Mukasey has said that it is permissible to hold Padilla as a material witness, they decide that they're going to transfer him to a naval brig down in South Carolina and hold him as an enemy combatant. Okay, what does that mean? Under the material witness statute, he had a right to counsel. As an enemy combatant, like Hamdi, the government says he doesn't have a right to counsel. Can he file a petition for a writ of habeas corpus? Sure, just like Hamdi could. Judge Mukasey, disagreeing with the Fourth Circuit, however, says that he thinks that Padilla should have the right to talk to counsel with respect to filing the petition for a writ of habeas corpus. Because how else do you challenge the facts if nobody even knows his side of the story? Part of what's different about Padilla from Hamdi is that Padilla actually had a lawyer. He had a relationship with Donna Newman and had seen her before he was transferred to South Carolina. So Judge Mukasey writes a very long opinion in the Padilla case. One of the things he has to deal with, too, is does he still have jurisdiction since Padilla is now in South Carolina and all this kind of thing. Notice, by the way, coincidentally, where the government keeps sending people, South Carolina, Virginia, the Fourth Circuit, the most conservative court in the country. Is this a coincidence? Okay, so Judge Mukasey, now differing from the Fourth Circuit, says that Padilla does have the right to counsel. The other thing that's very different about Padilla's case that has not yet been examined by any court, really, is whether or not Padilla can be held as an enemy combatant. Unlike Hamdi, Padilla was not captured in Afghanistan. Padilla was captured in the United States. And whether or not the Fourth Circuit's opinion would extend to an American citizen captured on American soil is very much an open question. And if you read the Fourth Circuit's opinion in Hamdi, one of the things the court keeps saying again and again is we're not talking about somebody who's been captured on American soil. This is somebody who was captured in an active combat zone in Afghanistan. That's different. We're not saying that this would apply to any, quote, enemy combatant who's captured within the United States. Okay, in addition to the original round of people who were being detained on immigration violations, you may also have heard that in connection with the government's program requiring people to re-register, people who are here with green cards or whatever to re-register, they have a whole list of countries where if you're from one of those countries, you had to re-register. When people showed up to re-register, lots of them were detained also. But again, most of those were on basis of they had overstayed their visa or whatever it was. So again, we don't know the numbers of people who are being detained. We don't really know what's going on. The Freedom of Information claim is pending. The Fourth Circuit decision is just kind of sitting there. Padilla is just kind of sitting there. At some point, there may be a decision on his status as well. Okay, I think maybe this is a good time to pause and see what questions or thoughts you have on the detentions and enemy combatants before I move on to also talk some about what's happening in surveillance. Any questions or comments on anything? Yeah, go ahead.
You mentioned a lot of when lawyers come forward, a lot of them will be charged criminally with these immigration.
Some. I don't know that it's a lot, but certainly there was some. Right.
I mean, how much of these charges that are just said, okay, hey, we have these immigration charges, how many people are actually in violation of?
Oh, many of them were in violation of immigration laws. Sure, there were a lot of people who did overstay visas.
So these are mostly people who have broken American
That's right.
law.
That's right. Broken immigration law. That's right. Yeah.
Well, I just want to comment to that because I worked in the immigration office last year, and the woman I worked for was actually representing a client in one of these situations. I mean, one thing we need to think about when we talk about immigration violations, I mean, look at New York. Look at how many people here are immigrants, and most of them are undocumented. This is a country that thrives on undocumented immigrant labor. So our policy of saying, like, they committed a crime, it's out of proportion with the reality of our country. I think most people don't realize that, like, most immigrants in this country are not here legally. It's just not a reality that they can achieve because of our laws. So we shouldn't, like, classify undocumented immigrants as, like, committing a major crime as very, like, illegal people. And just, like, a comment I have as I think about this, I wonder, what do they hope to accomplish by this? I really, like, the policy to me seems really defeatist to our country.
Which policy do you mean?
Well, like, detaining people for so long, it just seems like it would make people hate our country more. I mean, that's one thing I wonder, like, what is, I don't know the concept, but what...
Well, the government's theory is why they're holding on to people is, first they're trying to make sure, they want to make sure that somebody is not connected with terrorism before they let them go as part of the theory. And the other part of the theory is they're hoping for information. A lot of these people were detained where the government says they're not torturing anybody, but what they will do is hold people with the lights on all the time and try to break them down. They're doing serious interrogation of a lot of these people.
But I mean more than what are we going to do when this is all over?
Okay, well the question is when does it end too? Yeah. One of the problems, what some people have challenged the war paradigm in looking at, well, World War II, okay, that was a war. It had troops, it had uniforms, it had an end, it had, you could surrender, you could sign a truce, but how does this end? Somebody was pointing out that Ronald Reagan in his inaugural address was talking about the war against terrorism, fighting terrorism. In 1996, there was a major congressional act that was called the Effective Death Penalty and Anti-Terrorism Act, which restrained the ability to get habeas corpus review in different ways. So it's almost like the war here isn't like the emergency kind of war if you were sick with the flu. It's more like a condition. It seems to go on for years. And to imagine, when does this end? When do we let the people in Guantanamo Bay go? When do we release Jose Padilla and Hamdi? When do we say the war is no longer with us? So that's been one of the challenges to the war paradigm. I should tell you on the other side, because I'm debating Ruth Wedgwood at the City Bar Association Monday night, and this has been a lot of her argument. She argues that, in the same way that I want to argue that the war paradigm doesn't completely fit here, she argues that the criminal case paradigm doesn't really fit here, and that we shouldn't be prosecuting people like Hamdi or Padilla in court because the courts can't really handle it. The court rules are too stringent, they don't allow hearsay, and she says it's not practical. It's really not practical to say either it's a criminal prosecution or nothing, in the same way that you would certainly think that it's not practical to allow people their right to remain silent or your right to counsel or anything else. So she sort of starts from the war side and looks at the practicalities of the criminal prosecution model. Anything else generally on detentions? Actually, one more thing I actually was thinking I should mention to you. I think a lot of you know about this part too. But in terms of the deportations of a number of these people who are detained, another policy of the Bush administration with respect to this has been to hold, oh, thank you very much. That was very observant, as well as thoughtful. Another policy has been to hold the deportation hearings of all the post-9/11 cases, the quote, special cases, in secret. And the government's theory there, again, is that maybe it would help the enemy, maybe it would help the terrorists to know who we've caught and who we're detaining and who we're going to deport. And therefore, they want to hold all the deportation hearings in secret so that nobody can know the identities of the people who are going to be deported. There's now actually a conflict in the circuits on this issue because there was a case in Detroit involving a man called Rabi Haddad, an imam who had overstayed his visa. He was in violation of the immigration laws. And there was a deportation hearing that was about to be held. He had been there a long time. He had his whole congregation and all. And he was a very well-known person in Detroit. Well, the Detroit Free Press, as well as Representative John Conyers, asked to be able to attend his deportation hearing to see what was happening and the basis on which the government was going to be deporting him. And we're told that it was against the policy. The district judge in that case held that there was actually no good reason for not allowing the public into his deportation hearing, because the only reason that the government was articulating for keeping the proceedings secret was that they didn't want anybody to know the identities of the people who were being considered. Now, Rabi Haddad's name had been all over the newspapers, and everybody knew who he was. So the district judge there said, well, if that's your only reason, that's not good enough. She ordered the hearing to be open, and the Sixth Circuit affirmed that decision. You may also know that a similar thing happened in New Jersey, and although the district court ruled that the deportation hearing could not constitutionally be closed, the Third Circuit disagreed. And they said, again, on sort of the war model, if the government tells us that there are dangers here, who are we, the courts, to evaluate whether or not this is really dangerous, and whether we should be giving information to the enemy that might be useful? How do we know? We'd better defer. And so they say if the government wants to close deportation hearings, they can. Okay, there's now a split in the circuits. Where there's a split in the circuits, of course, it is possible that the Supreme Court might want to hear the case, because that's one of the things they do. So that conceivably could be the first case that comes before the Supreme Court in connection with all of this. What about closed deportation hearings? Okay, other questions or comments?
My question is, what role could or should international courts have in determining a resolution to these types of problems?
Okay. What role do international courts have in determining a resolution? Well, according to the Bush administration, the answer is really none. Because, they're viewing this as a war situation where we just get to make the decisions. That either we put people in American courts, we use military tribunals, or, as in the Hamdi and Padilla cases, we just hold people as enemy combatants. And you probably know the Bush administration has not been very anxious to give over authority over any American decisions to any international court. So, what you think should happen is obviously a different question, but that's, what is happening. Yeah, John?
You mentioned the hesitancy that the government has to prosecute anyone. To what extent, if any, has that been influenced by, like, the John Walker Lynn case?
Okay.
I know that obviously it's different because, again, he's a citizen,
Right.
but the problems that the prosecution initially ran into
Right.
there as a test case, did that influence their decision later
I think it's a good question. In terms of hesitancy, I'm not sure if that's the word that I would have chosen. Clearly, they've decided not to prosecute Hamdi and Padilla. And it might well be, what happened in the John Walker Lynn case, there are major opinions about that too, what were his constitutional rights. The other real problem case is Zacharias Moussaoui, who, talk about right to counsel. He had a right to counsel. He doesn't want a lawyer. And he's almost like, the poster child for what's wrong with putting somebody on trial, right? His view is, I want to represent myself, and I don't really care whether or not I'm convicted. I want to use my trial as a political platform. Okay, and that's what he's doing. And the judge in that case is having a very difficult time. You notice again what district where he was at, Virginia, right there on the Fourth Circuit. So, it's a real problem, and I understand, the government's concerns about wanting to put people on criminal trials. They're concerned about secure information and whether that'll be protected in federal courts. They're concerned about beyond a reasonable doubt proof. They're concerned about constitutional rights. They prefer the war paradigm. So, and yeah, I don't know that I would call it hesitancy to prosecute. I would just call it, that's not what they want to do. They're seeing a different method, and they're really just going with this other paradigm. And I think, to me, the problem is that neither the war paradigm nor the criminal paradigm completely fits. I think we're like, someplace in between, and nobody has figured out how to be in between. Oh, dear.
I have a question about how these decisions are being made. Is this very much a top-down effort, as in, George Bush and John Ashcroft making these decisions, or how much of a role does the Foreign Homeland Security Department have in making these decisions, and where they send detainees and who they prosecute and who they don't?
Okay, that I don't know. I think a lot of the power has been centralized, and one argument, and it's something that's a kind of recurrent theme here in the Patriot Act as well, is that the higher level the decisions are made at, the better. So the the Patriot Act says in a number of different places, the Patriot Act says this decision must be made by the Attorney General personally, or his one or two very high subordinates. And President Bush did make the enemy combatant decision himself, and the idea is that's better. I have no idea how the executive branch splits up its decision-making authority and who's listening to whom. What I can tell you, of who's out of the loop, is Congress. They've been very resistant to reporting to Congress at all. I'm sure you've read about many occasions where Congress has asked questions, and the executive branch has said, we can't tell you. This is our authority, Article 2, separation of powers. You have no right to know. So, there are a lot of arguments that we could talk about where Congress, I think, should play a greater role. But one of my themes in this whole discussion is that all the power, I don't know particularly who in the executive branch is executing more, using more or less of this power, but all the power is ending up in the executive branch. And Congress is ending up not doing all that much. They did enact the Patriot Act and provide all these powers, but they're not having that many oversight hearings. And then the courts, on the other side, have been involved in some of the decisions that I've been describing. Judge Kessler's decision in the Freedom of Information Act, the decisions in the deportation hearing cases, where there has been judicial review. Michael Mukasey saying, well, yes, Padilla should get a lawyer. There's no good reason to deny him one under limited circumstances. But on the other hand, then you have the Fourth Circuit in Hamdi and Judge Mukasey in the Padilla case really sort of deferring to the government's decisions about how to handle all of this. So to me, the problem isn't how is this happening within the executive branch. It's this tremendous concentration of power that's just ending up, all with the president. And the president's argument is, easy on the judicial review. Courts don't know, we know more, we're the experts, it's commander-in-chief. Easy on Congress. This is the presidential power, the president is commander-in-chief. And the Bush administration says, the answer here is political accountability. The only check should be political. People don't have to vote for the president again if they don't like what he's doing. But my problem with that, well, this freedom of information problem is, how are we supposed to know, as citizens, how are we supposed to provide political accountability if all this is happening in secret, if we don't know what's happening? Okay, other questions? Yeah.
We're currently in a war on drugs as well. They just lock up a guy till the end of the war on drugs. Is it the same type of argument?
Well, some people might argue that the war here is more metaphorical than real, clearly, rhetorical question, but good question. Other questions or comments, Michael?
Along those same lines, the semantic issue of the concept of war. Who are they, traditionally war is between nations, and in this case we're fighting against some non-indigenous rebellious group. They want to call that a terrorist group, they can call it that. But, so how do the people who are trying to use this war paradigm justify this change from traditional war to non?
They justify it by, most of the argument is that the stakes are so high, that so many people have already been killed and so many more people are at risk. That's the argument. In terms of...
They don't need to have this nation involved, it can just be some group that...
Right, it doesn't have to be a nation. And they're unlawful combatants because they're not a nation and they don't have uniforms and they don't march in here. That's the argument. And to me, that's one of the very, I hope you can see, in the enemy combatant issues, certainly, and in many of the other issues to come, the whole question of to what extent you accept this war paradigm is the critical question. Either you go on the sort of constitutional path, here are our rights, here's what we do in criminal prosecutions, it's business as usual, there may be a couple of exceptions, or are we at war? And we can just hold on to people until the end of hostilities, or however that applies. Difficult question. Okay, should I go on maybe for 10 or 15 minutes about the surveillance issues? Okay, let me tell you about some of this. Here I think we'll start with Congress. We'll start with the USA Patriot Act and some of the ways in which, I'll start with electronic surveillance. The usual model for electronic surveillance, called Title III, some of you in criminal procedure will get to this tomorrow, I happen to know. Title III says that the government can in fact do wiretaps and do electronic surveillance on people's telephones and all, if they go to a judge and they show the judge that they have probable cause and they show how they're going to minimize listening to conversations that they're not interested in, and there's a whole lot of procedural requirements, one of which at the end of the day is that when you finish wiretapping somebody, you have to give them notice, and then if you try to use that evidence in a criminal case, the person can move to suppress the evidence, etc. Now the reason there are all these procedures in Title III is that the Supreme Court had decided a case just the year before Title III was enacted, called Berger versus New York, where the Supreme Court had expressed some doubts as to whether it could ever be consistent with the Fourth Amendment to do wiretapping. They just thought it was pretty broad, because usually if you're doing the search, you're looking for a particular thing and you only look in the place where you're going to find the thing. When you're wiretapping, you listen to a whole lot of conversations, including of people who you don't suspect, because there's somebody at the other end of the conversation. So the Supreme Court had expressed a lot of doubts. Congress dealt with those doubts in Title III by providing lots of procedure. The Supreme Court has never exactly ruled on whether or not Title III is constitutional, but they've decided a few cases connected with it, and it looks like they probably think it is. There is, in addition, 10 years later, the Foreign Intelligence Surveillance Act in 1978 was enacted. And this was enacted as a kind of legislative compromise under the following situation. J. Edgar Hoover had been arguing that he had power outside of Title III to issue any wiretap order he wanted in the interests of national security. Title III was about crimes, investigating crimes, but that if he wanted to investigate somebody because of national security concerns, there was inherent presidential authority to do that, including the FBI, the Attorney General, whoever else. Well, around that time, Frank Church also had a Senate committee investigating one of the particular uses of J. Edgar Hoover's power that was claimed, which was the investigation of Dr. Martin Luther King, who had been under very heavy surveillance by J. Edgar Hoover. And, they followed him everywhere. They recorded everything he did. Well, the Church Committee decided that this was a problem, and so what they ended up recommending in the Foreign Intelligence Surveillance Act was that the government would be permitted to do surveillance, not of United States persons, as the Act said, but of foreign governments and their agents, because that was just different. They weren't Americans, under much different standards from Title III. To get a foreign intelligence surveillance order to do wiretapping, you don't have to show probable cause to believe that a crime has been committed, because you're not looking for evidence of crimes. You're just trying to gather information about what foreign governments and their agents are doing in the country. So what you do is you go to a special court, not a usual Article III court. You go to the Foreign Intelligence Surveillance Court, a group of formerly 7, now 11 judges, specially appointed to consider these applications in secret. And the government asks this special court if they can please have an order to do a wiretap. All they have to convince the court of is that the person they want to wiretap or entity is a foreign government or an agent of a foreign government. Now, if you look at the definitions in the Foreign Intelligence Surveillance Act, they're extremely broad, and you don't have to have a whole lot to do with the foreign government, especially if you're suspected of any kind of involvement with terrorism. So there can be, very broad-based wiretapping. One of the restrictions that was in the Foreign Intelligence Surveillance Act that was a very important limitation on this power was it said you can only use a foreign intelligence wiretap if the purpose of the wiretap is to gather foreign intelligence information and not to gather information of a crime. So there was this kind of wall put up. You want evidence of a crime, you have to do Title III and go through the whole rigmarole. If you just want to find out what a foreign power is doing, bug the Saudi embassy, then you can do this thing of go to the secret court. Well, the secret court, so far as we know, granted virtually every application that the government ever put before them because they didn't have to prove very much. Thousands of applications. Then comes the USA Patriot Act. One of the changes that Congress made, and this is why not many people know much about the USA Patriot Act. Section 218 of the Patriot Act, as you read it, says in Title 18, Section, 3217, I think it is, delete the word "the" and put in the words "a significant." You read that, you think, big deal. So then you have to go back and read the whole thing to figure out what that means. What does that mean? It means you no longer have to convince a court that the purpose of the wiretap is to gather information about foreign powers. It can just be one of your purposes. Does that mean you can also be looking for evidence of crimes? Yeah. Does that mean that now the FBI and the CIA can share information? Sure. According at least to the Foreign Intelligence Surveillance Court of Review. Okay, the Foreign Intelligence Surveillance Court in May of this past year was asked by Senator Patrick Leahy to report on what they were doing with this new power under the USA Patriot Act. He said, okay, I'm in the Senate, I'd like to know. We just gave you this additional power, it looks like. How are you using it? What applications are you getting? Are you denying any? Foreign Intelligence Surveillance Court writes back to Senator Leahy and says, well, funny you should ask. We've decided we're going to share with you this opinion that we just wrote, which denies 75 applications for wiretapping authority that the government just made on the ground that we think that they're getting a little too fuzzy here about meshing the Foreign Intelligence Review with the criminal investigations. They're sharing everything. The wall is down. We think it's a problem. We think that they should be using Title III if they're just going to be investigating crimes. Well, the government was very upset about this and didn't especially like that it was publicized. So what they did was they appealed to a court that had never before been convened, which was created by the statute, the Foreign Intelligence Surveillance Court of Review. 3 appellate judges appointed by Chief Justice Rehnquist who had to convene themselves for the first time. They don't really sit any place physical. And it was actually very interesting to hear the ACLU lawyer who was involved in this case talk about how in the world you file papers with a court that doesn't physically exist. Okay, this court had never met before. They had no precedents. They'd never published an opinion. Nobody knew how to do anything. So they're hearing the appeal of the government now because the government for the first time has lost a case with the Foreign Intelligence Surveillance Court. So the government appeals and asks for the decision to be reversed. The ACLU lawyer, Ann Beeson, decided that this should not be a one-sided proceeding, which it was. It was a secret proceeding only with the government as the only party. So she asked for permission with this court. She found out who the chief judge was on the court, and wrote to him and said, "Can I file an amicus brief?" And ultimately, they decided to let her file an amicus brief because they decided, well, they wanted to write an opinion, and they wanted to say why they were reversing the decision of the Foreign Intelligence Surveillance Court. So they wanted to be able to say, well, they've considered the Fourth Amendment arguments, they've considered whether it's constitutional. So they permitted the amicus brief to be filed. Of course, nobody gets to argue other than the government because this is just a one-sided ex-parte proceeding. So the court meets, and then they issue an opinion on November 18th that reverses the decision denying these applications to the government. And what they say is the change in the Patriot Act means that as long as a purpose, some purpose, the government just has one of their purposes is foreign intelligence, means they don't have to have a wall up. The Foreign Intelligence Surveillance Court was wrong. Is this a violation of the Fourth Amendment? Well, the Foreign Intelligence Surveillance Court of Review, considering these arguments from the ACLU amicus brief, does some analysis of special needs exceptions and things that only Fourth Amendment junkies need to know about. But what they say at the end of the day is, well, this is probably okay under the Fourth Amendment, but, and this is an amazing part of the opinion, they say toward the end of the opinion, well, even if this isn't exactly consistent with the Fourth Amendment, at least it's close. Okay, so there's this really amazing opinion by the Foreign Intelligence Surveillance Court of Review. They figured it out. They are going to publish it in the Federal Reporter. It has a site. You can read it. It's no longer an invisible court. But can anybody appeal this decision? The government was the only party, and they won. Therefore, theoretically, nobody lost. Okay, who has standing to challenge us? What about the people who are being wiretapped now? They don't know. Presumably, this is being kept secret from them, the fact that they're being wiretapped. So, after a lot of deliberations, a very creative move, just last week, the ACLU filed a motion to intervene and a cert petition with the Supreme Court. Okay, we'll see what they do with that one. This could be the first case before the Supreme Court if they want to hear it. Otherwise, think about it, the Supreme Court could never hear this issue because there's never a party to appeal it to them, right? Interesting, because the civil procedure fans, proper motion to intervene. Okay, one of the whole problems in this whole sequence of events has been the whole problem of standing. I was telling you before about how, can Padilla or Hamdi file a habeas corpus petition if they can't sign a petition or get a lawyer because they're locked up incommunicado, one problem. There was another case brought in California that was on behalf of the detainees at Guantanamo by a bunch of clergy and law professors and other people. And the Ninth Circuit, even the Ninth Circuit, held that they had no standing to challenge any of this. Okay, who has standing to challenge any of this? Why hasn't there been more litigation about the USA Patriot Act? Because nobody knows if they've been affected. The second provision, the only other one I think that I'll tell you about, and we'll see if there's other things you want to discuss in the Patriot Act, is Section 215, which also expands the Foreign Intelligence Surveillance Act in the following manner. It used to be that the government could get documents, records, whatever they wanted, whatever kind of information about people who were, again, foreign powers or agents of foreign powers with this very loose definition. Anybody who you suspect of terrorism, even if they are a citizen. All they had to do was get a court order, but the court order here, too, is kind of illusory because all they had to say to the court was, we really want this information, we think it's relevant to our investigation. Well, it used to be under the Foreign Intelligence Surveillance Act that the kinds of records they could get and the kinds of parties, the custodians of records who would be subject to this order were very limited. It was common carriers, maybe the telephone company or a couple of other places. What 215 now says is this applies to everybody. Anybody who has any kind of record that the government is interested in, the government can get a court order under the Foreign Intelligence Surveillance Act and order the custodian to turn over whatever kind of information the government wants, subject to, again, there's a court order, but it's not really based on any findings, so it's a real rubber stamp. And, furthermore, Section 215 provides a gag order to the custodian. If you are asked for information like this, you are not allowed to tell anybody that we've asked. Who does this apply to? Who's upset by this? Librarians. The government, in at least some circumstances, has been going to libraries for information about what people have been reading. Who's been reading interesting books that the government would like to know about? Educational institutions. The government has been getting all sorts of student records. And another provision in the Patriot Act makes an exception to former law that provided for privacy of student records of different sorts. Just takes that away. The government can just go fish among student records. And they do, clearly. They clearly are asking for, show us the records on all your foreign students. Internet providers, okay, all sorts of people are covered by this, and they're not allowed to tell. The American Library Association, if you visit their website, they recently had a whole teleconference about this, getting librarians all over the country to talk about how they're doing this. It's hard for them even to talk about what they're doing because they're not allowed to tell anybody if this had happened to them. Right? In October, I think it was, in Illinois, somebody did a study saying that this power had been used 85 times, and that people had gone around to, the government agents had gone around to bookstores and libraries and had in fact been using this power. How they know that is beyond me, especially since nobody was supposed to tell. Okay, so who has standing to challenge this? The librarians aren't allowed to say. Do the customers know? Do you know if somebody's been reading the record of what books you took out from the library? No. Okay, so who has standing to challenge this? Well, once again, the ACLU to the rescue. The ACLU, just on a couple months ago, I can't remember the date that this was filed, with various plaintiffs, like librarians and so forth, has brought a Freedom of Information Act claim down in the District of Columbia, asking the government to tell whether or not it's been using this power and against whom. If the librarians aren't allowed to say, where do you get the information from? Sounds like it has to be from the government, right? So depending on whether or not there's any information that comes out of that case, depending on that case, maybe the librarians and other people would be able to challenge the constitutionality of that provision of the Patriot Act. But so far, it hasn't happened because either the people who know are not allowed to say, the people who don't know, and nobody else has standing. Okay, so that's that surveillance provision. Okay, do you have questions or comments, or do you want to hear a little bit more about the surveillance? Yes.
What do you mean that they can't tell what happens to them?
They can't, it's a gag order. They're not permitted to say that they've turned over records. Presumably. Yeah. Okay, let me just tell you one more then. I'll tell you one more surveillance bit. One other thing that the Patriot Act does is it used to be that one exception to Title III was that the government could get what we call pen registers and trap and trace orders, which meant that you didn't have to go through Title III and the whole rigmarole of getting a court order if all you wanted were the telephone numbers to which somebody was making calls and from which they were receiving calls. Because what the court said was that's not the same as the conversation. It's not the same as the content of the conversation. Well, the Patriot Act now expands that to email and to internet addresses. Okay, what's the difference between telephones and email and internet addresses? Okay, obviously the emails travel with their content. The government, with their carnivore technology, when they want to keep track of who you're sending emails to, which again, they can do all this under the Foreign Intelligence Surveillance Act, and we'll never know, and the internet providers are not allowed to tell, etc. So they get the email as well as the address because that's how it travels. And the government says, okay, we get it, but we promise we'll separate them out. Okay, we won't look at the content. We understand that we're really only authorized to look at the addresses. Just a week or two ago, I was speaking at a federal judicial center training session for magistrate judges, and I was speaking with a magistrate judge from Wisconsin, from Milwaukee. And it was very interesting because as an academic, I look at this act and I think this is terrible, this looks unconstitutional. How do we know the government isn't going to look at the content? Well, this magistrate judge, Aaron Goodstein, had a very good answer to that. When the government applied for their court order, which didn't really require him to find probable cause or anything, what he did in his court order was he said to the government, okay, show me how it is that you're not going to look at the content. And the government said, oh, well, we're only going to look at the keystrokes and they're done. He said, sounds like content to me, denied. So it was fascinating to me that the answer to how do you know the government isn't going to look at the content is we have these judges here. We do have judicial officials who can, in fact, make this happen. So I think that one of the problems that we're having right now is that so little is known about what's going on, either with respect to the detentions or the surveillance. Partially, the government wants a curtain over everything it's doing. Part of that, again, is this whole war paradigm that we don't want to tell anybody what we're doing because what if it helps the enemy? And in the meantime, people don't know, which is why there hasn't been more litigation. What I've just described to you is pretty much all the litigation that has taken place on these issues. Actually, one exception, there are also a number of discrimination cases brought on by dark-skinned men, not only Arab and Muslim, but dark-skinned men of all sorts who have been ejected from airplanes, another source of frequent litigation for the ACLU. A lot of people have been kicked off airplanes because the other passengers were nervous. Okay, claim that this is a problem, this is a denial of equal protection too. Okay, any other questions? Sandra?
What in terms of obtaining standing, what if these libraries
Act does permit surveillance of citizens as long as it can be shown that they're connected somehow. We suspect them of connections with terrorism. It's a very loose definition. But there's one difference in the treatment. What the Act called United States persons, you're not allowed to do a surveillance of a United States person on the basis, on the sole basis of activity that is protected by the First Amendment. Okay? Sole basis. Does that mean that that can be one of your bases? Yes, it does. Okay, but still, that's a protection that non-citizens do not have. Under the Patriot Act, if you say, I think Al-Qaeda is great, that's it. That can be sufficient, even if it's, would otherwise be First Amendment protected activity, if it's something that a citizen says. Plus, another thing that the Patriot Act does is it says that even if it's First Amendment activity, people belonging to an association or group or whatever, that First Amendment speech can be used as a basis for exclusion from the country. You can be not let in because you've been saying things like, I think Al-Qaeda is great, or whatever. You probably also know the Patriot Act also has a lot of other provisions about associations. It allows the Secretary of State, not the Attorney General, to designate any group as a terrorist organization. Okay, and at that point, he has a list at this point, is it 27 or 37 terrorist organizations? And some of them are multi-purpose organizations. I'm sure you've read about there are a lot of Muslim charities that are believed to be funneling some money to Al-Qaeda or some other group. Do they also have a lot of legitimate purposes? Sure. That's one of the things that happened to Rabi Haddad in Detroit. He was involved with a Muslim charity. And, I think that there's not a lot of evidence that was with anything other than a completely commendable purpose of starting orphanages for Muslim children or whatever. What the Patriot Act says is if you belong to one of these organizations that is designated a terrorist organization, there's no judicial review of the designation. It's just a final designation. If you belong to one, if you're not a citizen, you can be deported, period. Okay? That's just it. It doesn't matter whether your only connection with the organization is that you were paying dues or contributing to the charitable part. There doesn't have to be any proof that you even knew about the organization's illegal aims. That, again, that's not citizens, but that makes you subject to deportation. There are forfeiture provisions, pretty stringent forfeiture provisions, and a whole lot of financial reporting provisions also connected with such groups. Hey, John?
I was wondering, in the news this morning, there was two men were arrested for activities when they were in Brooklyn. They were being held abroad. Part of which was raising money at the mosque on Atlantic Avenue here that was eventually going to terrorist groups.
Right.
But the news story is quick to say it's not clear that anybody in the mosque knew this is where the money was going.
Well, it may be. The scienter probably has to be proved to charge them with a crime, but they could be deported. If they're not citizens, they could be deported on the basis of that. Or it could be subject to forfeiture.
Just on the basis of having...
Yeah, just on the basis of paying dues, being involved with the association. Again, that's one place where the Act treats citizens and non-citizens differently. And whether you could prosecute a citizen for a crime is a whole different question. Blake?
And at the same time, wouldn't those people be subject to criminal prosecution for any information? Wouldn't that subject them to wiretaps from the government?
Sure.
Therefore,
Sure, absolutely. That could certainly be used as a basis under the Foreign Intelligence Surveillance Act to wiretap, to find out what internet addresses they've been going to find out to whom they're sending emails and from whom they're getting emails, to look at their student records, etc. Sandra?
Is there any greater level of protection for, say, resident aliens versus aliens?
There's not a whole lot greater protection for resident aliens than other aliens. And one of the things that I find actually concerning about the Patriot Act and a lot of the Department of Justice reactions here is that immigrants are really bearing the brunt of this. And it's not only illegal immigrants. The Patriot Act does not only go to terrorism, it goes to many criminal investigations. And it certainly doesn't only apply to terrorists. Yeah, I think that people outside of a law school community wouldn't quite get that. And if the government says, well, we suspect this person of terrorism because he overstayed his visa, or because he lied on an application form or committed some other immigration violation, I think people would not draw the fine distinctions that you're drawing. And a lot of it is anti-immigrant. One of David Cole's theme songs here is we talk a lot about balancing your liberty and security. Well, easy enough when it's somebody else's liberty. Who's been detained so far? So far as we know, a couple of U.S. citizens, but it's just Hamdi and Padilla. And so far as we know, are any of us subject to surveillance? Is anybody checking our library records? Probably not. Not that the people who have this happen to, who are having this happen to them now know it. Karen?
If a constitutional challenge is brought, do you believe the standard of review would be strict scrutiny? And do you
The
believe
constitutional challenge to what?
someone found that monitored under the Patriot Act.
Right,
And they wanted to challenge it
right.
in the court system. If possibly it could make its way to the Supreme Court,
Right.
do you believe the standard of review would be strict scrutiny, and if so, would it be under something such as suspect classification?
Okay. I think not likely, because the Patriot Act doesn't really draw distinctions between people on the basis of race. It's just, U.S. citizens versus not U.S. citizens in part. And the chief challenges to the Patriot Act, I think, under the Constitution would be under the First Amendment, under the Fourth Amendment. At this point, we would have to start getting heavy and technical into con law, because I would have to ask you to start thinking about, if you want to think about constitutional challenges, you haven't done this part yet, but you have to look at all the different amendments and see who exactly is protected. Okay, some of the provisions say, the Fourth Amendment, for example, says the right of the people. The Supreme Court, in one case, Verdugo-Urquidez, has defined the people as citizens. So there was a case where the DEA, the Drug Enforcement Agency, was, destroying somebody's house, just entering it, clearly not complying with the Fourth Amendment in Mexico. And the court says, well, it's out of the country and it's not a citizen, who cares? The Fourth Amendment doesn't apply. And in fact, they say in dicta, they say it's not clear to us. We're not really deciding whether or not the Fourth Amendment would apply to non-citizens in the United States, because it's the people, and that sounds to us like maybe it means citizens. On the other hand, the Due Process Clause says you can't deprive any person of life, liberty, or property without due process. Does that apply to non-citizens? Of course. But under immigration law, there's a distinction. You get the due process if you're in the country and they're trying to kick you out. You don't get the due process if you're out of the country and you want to get in. Okay, so there are a lot of distinctions that are being drawn there. And again, there haven't been many constitutional challenges to any of this at all. I know that people are going to have 2 o'clock classes, so maybe I think this may be a good time to close the formal part, and then I'm happy to hang around if anybody has additional questions or comments. Let me also tell you that if you want the full picture, if you want to hear what the government is doing, I think this is actually announced on the web course, but Monday night at the New York City Bar Association, in a proceeding open to the public at 7 p.m., right up there on 44th Street, I'm doing a debate with Ruth Wedgwood, who's been the chief person, who's been sort of the architect of a lot of the government's theories here. She's going to talk, I'm going to talk. John Furyk, former dean of Fordham Law School, is the moderator. Judge Malonis is introducing. It's a whole big thing. You're all welcome. And I would love to see either friendly faces or people who want to interrogate me too. So I appreciate all of your attention. And all I can say, since this is sponsored by the American Constitution Society, is support the Constitution, and the BLS ACLU, this is a really good time to become a member of the ACLU, because look at everything the ACLU is doing, and nobody else is. So thank you all for being here.
To thank the ACLU for their co-sponsorship. I have a few quick announcements. We have flyers about the event that Professor Herman was talking about. It's next Monday. They're right there in the back on the table at the New York Bar Association. A few other quick announcements. The American Constitution Society has a few events coming up. On April 14th in the Subotnick Center from 4 to 6, we have Doug Jones, who is the attorney in the Birmingham church bombing case, the one that recently they prosecuted the Klans members who killed those young black girls back in the 60s. He's going to be speaking about that on April 14th in the Subotnick Center. On April 23rd, also in the Subotnick Center, we're going to have the public advocate, Betsy Gottbaum, come speak about the role of the public advocate here in New York. Tonight at the Union Bar, we're also having an event from 6:30 to 8:30. That's in Union Bar in the city. If you received an email about it, you do need to RSVP for this event, so just come see either myself or John Knapp at the end of this if you do have any questions about that. And also, as I mentioned before,
What's the event?
oh, I'm sorry. There's basically a free whiskey tasting. Johnny Walker is sponsoring a whiskey tasting, and we're just taking advantage of that as an opportunity for progressive groups all across New York to meet and brainstorm and plan events for next year. One of those events actually is that we're planning a progressive speaker series for next semester, for next Thursday. So, as I mentioned before, if anyone has any speakers or any topics that they're interested in, come see one of us. We'd love to have your speaker come talk. Thanks again.